My greetings to all the participants today. As in the past, we try to find subjects which are useful for our co-professionals, bankers, entrepreneurs, lawyers, and the society at large. Whosoever is required to have the knowledge of insolvency law, because this insolvency law is kind of applicable to everyone in the country, whosoever presently has some company under their management or has given some kind of personal guarantee to any loan. So therefore we keep doing this. So this time we have done our research on most of the Supreme Court judgments on insolvency and bankruptcy law. And today we would be discussing that. So the entire research is divided into part 2, and part 1 would be deliberated today, and the part 2 would be deliberated on coming Sunday at 4 p.m. I will introduce my co-panelist today. First, I will introduce Mr. Santanu T Ray, who is a experienced banker, an advocate, and an insolvency professional. He is a senior partner of AAA Insolvency Professionals LLP, and he's based out of Mumbai. So he is in charge of our Mumbai office of AAA Insolvency Professionals.
Good afternoon, everyone.
We also have advocate Aditya Gauri, who has about 5 years of experience, and most of it is in insolvency and bankruptcy law. He's regularly appearing before NCLT, NCLAT, and other forums, wherever any matter which is having any concern of insolvency. So he specialized into insolvency law. So I welcome you to both to this webinar.
Thank you.
So our endeavor would be to present this in such a simple manner, in simple words, so that it is applicable, it is understandable to all the stakeholders. As we always say that there is no other objective. I normally say that this is my way of learning, and I think we can jointly say that it is our way of learning. So I think you agree with me, Shantanuji, that it is our way of learning. There is no other objective. So there is no other objective. So this is our way of learning. Believe me, when we do the research and we read before we present, actually it adds to our knowledge, it adds to our confidence, it adds to the confidence of our teams, and it adds to the confidence of all the partners. As you know that we are doing 190 cases under insolvency law with 34 designated partners and 12 associate partners. So this effort, this research will boost the morale and confidence of all our team members and partners. So today we would be discussing 3 main subjects. So what we have done is that we have divided our research into parts. So we have collated all the judgments on one particular issue in one go, and we have also kind of make it orderly in chronological order, and the oldest judgment and then what, that kind of analysis that we have done. So the one judgment is only on the personal insolvency, then we'll move on to the limitation law, and there are multiple judgments on limitation law. And then we will move on to the commercial wisdom of committee of creditors and the various orders on resolution plan. So this will be the order today, and all the remaining issues will be attended in part 2 of this subject, that is judgments of Supreme Court on IBC. So before I go on, I would actually share the screen. So I hope this is visible to the panelist.
Yes.
So these three topics would be discussed: personal guarantors, limitation law under IBC, and resolution plans and commercial wisdom. So the first which we need to understand is regarding the personal guarantors, and I will ask Advocate Aditya Gauri to brief us about this order.
Right. So good afternoon, everyone. I'll just briefly take you all through the happenings, how the personal guarantors judgment came across. So the central government wide notification dated 15th of November 2019 brought into force the provisions relating to the personal guarantors to the corporate debtors. And it came in effect from 1st of December 2019. Now, while this notification was notified by the central government, there were several petitions, including the infamous petitions of personal insolvency against Anil Ambani was also filed before various high courts across the country. Now, several petitions were filed in different high courts challenging the said notifications, and challenges were also made to the related rules and regulations thereto. Now, while directing the transfer of petitions from high courts to itself, the Supreme Court noted that the code was at a very nascent stage, and hence it was better that the interpretation was done by the Supreme Court itself instead of various high courts across the countries adjudicating on the said matter and creating anomalies amongst themselves. So the basic issue that was taken up during the issues involved in the Lalit Kumar Jain versus the Union of India judgment for the personal guarantors, there were issues involved that whether the impugned notification dated 15th of November 2019 was that constitutionally valid in the first place. And while dealing with the issue of constitutionality, there were contentions that the notification takes away the protection of the personal guarantors afforded by law under the contract of guarantee. So the Supreme Court also took into consideration and adjudicated upon the matter that whether a resolution once passed would absolve the personal guarantors of their liabilities to the corporate debtor. So the ultra virus provisions and coming to the constitutionality of the notification, the Supreme Court held that it was very much in the power of the central government that Section 2A was brought into question and brought all three categories of individuals, be it the personal guarantors to the corporate debtor, partners of firms and partnership firms and other partners, as well as individuals who were either partners of personal guarantors to corporate debtors under one umbrella. Section 60 was mentioned by the Supreme Court, and it was mentioned that the code contemplated that the AA with respect to the guarantor, AA being the adjudicating authority with respect to the personal guarantors, would be the NCLT. This was particularly done so that the NCLT would determine the cases relating to a particular corporate debtor and the personal guarantors and the corporate guarantors thereto under one forum, and they can consider all the anomalies that are emanating from the said matter or the CIRP or the liquidation, and they can be dealt with by the same NCLT and by the same bench. And it would have been difficult for the executive to selectively bring into force the provisions of Part 3. The Supreme Court also talked about the parliamentary intent. Sir, I'll just ask you to go back on this particular point. So Supreme Court was also also mentioned about the parliamentary intent. The Honorable Court was of the view that the parliamentary intent of the notification was to treat personal guarantors differently from other category of individuals. Now, prior to 2018 amendment, the insolvency proceedings against the personal guarantors was to be only initiated as per the Presidency Towns Insolvency Act and the Provincial Insolvency Act, which was in effect also contended before the Supreme Court that this was not brought down in force. And consequently, the intimate connection between such individuals and corporate entities whom they stood guarantee was getting affected when two separate processes were being carried on. So in the end, the Supreme Court clearly said that the said notification was very much intra vires the Constitution, and it was very much in force. The other point, which was dealt in Lalit Kumar Jain, and one of the very important points was that the personal guarantor's liability does not absolve once the resolution plan is passed by the adjudicating authority. Now, this particular point, since we already have a chapter determined and dedicated to this resolution plans and the commercial wisdom, we will, or Anil sir will be taking this particular point in that chapter. We can go on to the next topic, sir.
Shantanu ji, would you like to say something on this particular judgment, which is the regarding personal guarantors? You are mute. Yes.
Yeah. So what has happened is it's finally gives a lot of clarity, absolute clarity, that personal guarantors can be proceeded against, and under to the corporate debtor they can be proceeded against. So from insolvency professional point of view or from lawyers point of view, we actually will now see a lot more of these proceedings being undertaken by the creditors against the personal guarantors. So I think this puts the whole issue of the legality or the constitutionality of this thing, and that the fact that personal guarantor liability, though is coexistent, but since it is by operation of law that the CIRP is happening, so the personal guarantee does not get absolved. Guarantor does not get absolved, and it continues. So this is a absolute clear judgment. I think it sets all the questions to rest.
So I think a new era of insolvency practice has started.
Yes, sir.
With this judgment, the Supreme Court has clarified that the insolvency of personal guarantors can be proceeded against. So there are two jurisdictions which I would like to explain here. One, that there is a company which has taken loan and the company has defaulted, and there is a person who has given personal guarantee to that loan, and that personal guarantee has been invoked by the financial creditor, and the guarantor has not been able to make payment. So that's a default. So the conditions are that number one, that there is a corporate debtor who has taken loan, who is a borrower. There is a guarantor who is a personal individual guarantor, and there is a default by the company, and there is an invocation of personal guarantee by the financial creditor, and then there is a default because the person has not been able to make payment as he provided a surety to that loan. Now, this new era of individual insolvency, for which the regulations and rules have already been notified, there are two parts of this. One is that the insolvency can be filed by the creditors, and also the insolvency can be filed by the personal guarantor.
Yes.
To my understanding, this is an opportunity for the personal guarantors to file their insolvency and start their life afresh. Because I have gone through this personal insolvency law, and it provides a kind of new life opportunity for an individual. So presently, what are the options available without this personal guarantor's insolvency? The options available is that the financial creditors will proceed against the guarantor in DRT court, and maybe they will also start SARFAESI action in case there is a collateral security given by the personal guarantor. The DRT will proceed against the case, and finally there will be a recovery order. Then it will go to the recovery process, and the recovery process will start, and somebody would start locating the assets of that individual, and finally those assets will be attached, and the sale process will be handled by the debt recovery tribunal. And see, this might even take 10-20 years, and even after that the individual would not be able to do business and will not be able to have any asset in his own name, because this recovery certificate can be exercised anytime. So once a defaulter, once a personal guarantor, he will never be able to have any other business in his own name. He will never be able to own assets in his own name, and his basically commercial life would be almost shut. The commercial life of this kind of person will die. My suggestion to all these persons are that they should avail this opportunity. They should uh, file their own insolvency. They should see in case there is a process of repayment, and once the repayment is accepted by the bank, that means that the personal insolvency would be, the repayment plan is accepted, and if he pays, that means that he is absolutely not having any stigma of bankruptcy also, and he can make a payment of in installments, and that may be accepted. But in case he is not able to make any payment to the financial creditors, then he can also ask for the bankruptcy. And after the bankruptcy order starts, within 1 year, he would be discharged. Even if whatever assets are owned by him are not sold, even if the matters are still pending in the courts, but he would be discharged after 1 year. And once a person is discharged under this bankruptcy law, then thereafter, very next day, he would have all the powers to do business. He would be able to become like hold shares, hold assets, hold his own residential house, hold cars, and he will have a fresh commercial life after 1 year of bankruptcy. So this is an opportunity for all the professionals to suggest to their known clients or friends, whosoever are undergoing financial stress. It used to be a little different era when the business was being done after the defaults in the name of relatives or in the name of some of the trusted employees. Now that time is over. It is very difficult to put your all assets in the name of other people, relatives. So you actually become dependent on them. So my suggestion is that this particular judgment should be used as an opportunity by the professionals, as an opportunity by the financial creditors, as an opportunity by the guarantors also. So now we move on to the next subject, which is the limitation law. So we have researched on 6 orders of Supreme Court, and then finally we also analyzed the suo motu order, which was given by Supreme Court on account of the COVID pandemic. So where the limitation law was applied on, and the period of COVID was excluded from the filing or limitation period as mentioned in any law for filing any petition or appeal. So we'll start with BK Educational Services, and the structure of this slide is that F means the facts, then I means the issues in that order, and H means held portion. So now we will actually do this BK Educational. So Aditya would actually talk about some facts and issues, and then the held portion would also be kind of spoken. So, so in each order, we have these 3 segments. So I would request Advocate Aditya Gauri to talk about this particular order, which is BK Educational versus Parag Gupta and Associates. You can also see one, because this particular order is 2018, and then we have orders of Babulal Vardarji Gurjar and Kalparaj Dharmshi. So all these are basically in chronological order. Yes, Aditya.
Right. So BK Educational Services Private Limited judgment was in fact a very groundbreaking judgment when it comes to the applicability of limitations to the Insolvency and Bankruptcy Code. So before this, there were various the NCLATs and the NCLTs were in a state of quandary. The banks were in a state of quandary whether the limitation would be applicable to the NCLT cases, the IBC cases or not. And there were judgments by NCLAT which suggested that the limitation laws were not applicable to the IBC code. Now, then came the BK Educational, in which I'll just briefly go through the facts, whereby Parag Gupta and Associate was a financial creditor who had filed an appeal before the NCLAT against an order of the adjudicating authority, whereby the section 7 of the code was rejected because it was barred by limitation. The NCLAT held that the Limitation Act would not be applicable to the initiation of CIRP, as I just suggested. In various other cases, the NCLAT had also taken the same stance. And where the financial and operational creditors are able to reasonably justify their delays in filing applications, the same can be entertained. The decision of NCLAT was challenged by the corporate debtor before the Honorable Supreme Court. Now, while the appeal before the Supreme Court was taken up and the arguments were being heard, the amendment of Section 238 was inserted in the code with effect from 5th of June 2018, which provided that the provisions of the Limitations Act shall, quote unquote, as far as may be, apply to the proceedings or appeals before the adjudicating authority under the code or the NCLAT, DRT, DRAT, as the case may be. So this is where the amendment came in. Now the question was whether the Limitation Act would apply to the applications filed by the financial creditors and the operational creditors for initiation of CIRP before amendment. The BK Educational Services contemplated on various issues, went through various judgments and held the following. Anil sir or Santanu sir, if you want to just...
Okay. So what was held that, relying upon the Insolvency Law Committee report of March 2018, the court first held that the intention of the code was not to give a fresh life to a already time-barred debt. So it was not like if a debt has been time-barred for last 10 years, just because IBC has come into effect from 2016, it was not the intention to give it a fresh lease of life. The NCLT, which was established under the Companies Act and the adjudicating authority under the code and Section 433 of the Companies Act, makes the Limitation Act applicable to NCLT. Therefore, the Limitation Act will be applicable to the proceedings under the code as well as NCLT as this thing. Now, again, Section 238 of the code is a clarification of the law and procedural in nature. Since Section 238, it's of retrospective in nature, it is intended to be retrospective, then the amendment to Section 238A would also be retrospective. So the question whether this thing would be prospective or retrospective was answered that this is intended to be retrospective. It was also noticed that the expression due and payable under Section 311 and Section 312 refer to a default which is non-payment of debt that is due in law. So a time-barred debt is due, but it is definitely not due in law. So, which means, and Section 7 and 8 of the code make it clear that CIRP can be initiated by a financial operational creditor in relation to debt which have not become time-barred. Rejecting the argument that applying the Limitation Act may lead to an anomalous situation, the court held that even though there is one appellate forum under 3 statutes, each appeal would be decided keeping in mind the provision of the particular act in question. Section 6 further held Section 60, subsection 6 of the code, which provides for exclusion of moratorium period in computing the limitation period of a suit or application against a CD would have been wholly unnecessary if the intention of the legislature was to exclude the application of Limitation Act from the code. So while examining Section 433 of the Companies Act and Section 238A of the court observed that both these provisions make Limitation Act applicable as far as it may be. This is a very important this thing, as far as may be, and thus in the event the code specifically provides for certain limitation periods, the same would override the Limitation Act. For example, if there is a limitation of 45 days for filing a appeal before NCLAT, so that would prevail over any other limitation this thing. So it is as far as may be. The next page, please.
So I think this there are two. Why this judgment is important, because this was the first order on limitation law by Supreme Court for IBC law, and it also kind of cleared the clouds on account of NCLAT order when it was held that the IBC law is not applicable to a limitation law is not applicable to IBC. Otherwise, it would have been a case like people may even come out with 20, 30 years old cases. So that actually has been completely avoided in this case. So this was the first important judgment, and also because of that NCLAT order, this amendment in 238A of the code was also inserted. So this was also made retrospective in this order of the judgment. So the two important parts, I think we can move on, and finally we will crystallize. We will move on to this Babulal Vadarji Gurjar versus the
Gurjar Aluminium Industries.
versus Veer Gurjar Aluminium Industries Private Limited. So in this case, I think Aditya can see the facts.
Yeah. So the appellant in this particular Babulal Gurjar case served as a director of the company, the corporate debtor. Now the respondent number one failed to pay its loan, and henceforth the recovery proceedings. When I say the respondent number one, I mean the corporate debtor and the respondent in the appeal before the Supreme Court. Sorry. Now, the respondent number one failed to pay its loans, and the recovery proceedings were filed against it in DRT on November 15th, 2011, as per the provisions of SARFACI. Now, during the pendency of these proceedings on March 21st, 2018, the SARFACI proceedings were going on, and there was stay and there was no stay. And while the proceedings were going on, the financial creditor of the respondent company, which is JM Financial ARC Limited, opted to file an application under Section 7 for seeking initiation of CIRP of Virji Gujar Limited. Thereafter, the appellant filed an appeal before NCLAT. The application was, of course, admitted by the NCLT. Now, the appellant filed an appeal before the NCLAT, which contended that the debt is time barred because the date of default was July 8, 2011, when the SARFACI action was initiated. Now, NCLAT dismissed the appeal, stating that the right to initiate an application under Section 7 accrued only on December 1st, 2016, when the IBC came into force. And when it comes to the mortgage properties or the dispute related to the properties, the period of limitation as per the Limitation Act is 12 years. Now, again, another anomaly was given heed to that whether Article 137 would be applicable to the IBC, Article 62 would be applicable, whether Section 5 and Section 14 would be applicable, and 18 would be applicable to the IBC. Now, the issues which were dealt by the Supreme Court in this particular matter was whether the Limitation Act would apply to the applications filed by the financial and operational creditors for initiation, and whether the triggering point for initiation application under IBC is date of default or the date on which the code came into force, that is on in 2016. And the second was that what is the limitation period for which a person is supposed to file an application where the property had been mortgaged by the debtor, and whether Section 18 of the Limitation Act, which talks about whether recurring acknowledgement gives you any more power to condone the said delay, can be used to extend the limitation period.
So this was also an important order. It was held in this case that this limitation, the limitation law would be applicable commencing from the date of default and is extendable only by application of Section 5 of the Limitation Act. Now, Section 5 of the Limitation Act deals with the power of the court where the reasonable cause, wherever reasonable cause is established. So that is the power of court under Section 5 of the Limitation Act. And wherever the court find that the applicant was the applicant was restricted and there was a reasonable cause that he could not take action on time, so that they can be condoned under Section 5. So there are other sections starting from Section 12, 13, 14, I will come to later, but this particular order was important one to say that the date of default is the commencement of limitation period. And secondly, it was very important in this order that it was saying that even if a collateral security, even if there is a security interest, even if there is a mortgaged property, but that the limitation period would be 3 years, and it would not be extended to 12 years, because that 12 years is only applicable while there is a process of recovery of dues. So it was held by Supreme Court that this IBC is not a process of recovery of dues. Therefore, the 12-year period is not applicable. Even if there is a mortgaged property by the financial creditor, it will only be restricted to 3 years. So this one is that the limitation will start from the date of default. Number two, 12-year period is not applicable. So these are the two findings of the court in this case. And then the court held that the extension of limitation period can only be done in accordance with the provisions of the Limitation Act. As I said, that section 18, like the acknowledgement of debt. Of course, later on, we have also Vishal Jazwal judgment, where it was very clearly held that the acknowledgement also would be considered as extension of period. So in this case also, the acknowledgement was also held to be the extension of debt. Now coming to the Kalpraj, Dharamshi and others, it is basically Kotak Investment Advisors Limited, and the judgment is as latest as 10th March 2021. I think Aditya, you can take up the facts and then we'll.
Kalpraj Dharamshi judgment also in this particular judgment as well, Supreme Court dealt with two particular cases. One was supposed related to the limitations and whether section 14 would be applicable and how that particular section would be applicable to this matter, and about the commercial wisdom of the COC. Now, in this particular case, the adjudicating authority admitted an application filed by the corporate debtor under section 10 of the IBC for initiation of its CIRP. The RP, as per the provisions and the regulations of the code, invited the resolution applicants to submit their resolution plans. Now, there were two resolution plans which were submitted by the RAs, namely Kotak Investment Advisory, I'll refer to it as Kyle, and Kalpraj, the appellant herein, who had also filed a resolution plan in consortium with one of its partners. So Kyle placed its objections before the RP regarding Kalpraj submitting the resolution plan beyond the prescribed time limit, which was mentioned in the information memorandum as published by the resolution professional. Now, in the meeting of the COC, the resolution plan of Kalpraj was placed before it, negating the objections of Kyle, and the COC directed that the applicants to submit revised plans. Accordingly, Kyle and Kalpraj both went out and then came with their revised plans. And in the meeting of COC, the plan submitted by Kalpraj and in consortium came to be approved by the majority, which was placed by RP before the NCLT for approval. Now, aggrieved by this, Kyle filed an application objecting to the plan of Kalpraj on the ground that RP was not justified in permitting Kalpraj to submit a plan beyond the prescribed date. And secondly, what adjudicating authority dismissed the application of Kyle and approved the resolution plan thereby. So thereby aggrieved by the order of the adjudicating authority, Kyle, instead of approaching NCLAT, went to the High Court in writ jurisdiction to challenge the principles of natural justice which were infringed during the said proceedings. It was said that the contention of Kyle was that the contentions and the arguments were heard by the judicial member and the judgment was given by the technical member of the NCLT, and hence they went to writ court. Then the writ court had with a detailed order dismissed the said writ, and they asked Kyle to approach the NCLAT. NCLAT also rejected the Kalpraj argument that the appeals were filed beyond the limitation. So NCLAT, in front of NCLAT, it was arguments of Kalpraj that this was a limitation. The appeal was barred by limitation since 45 days had already elapsed. So being agreed by the aforesaid order of NCLAT, 4 appeals simultaneously and parallelly were filed before the Supreme Court. Now the issues which were taken up by Supreme Court while tagging all these 4 appeals was whether the appeals filed by Kyle before the NCLAT were within limitation, and whether NCLAT was right in law to interfering with the decisions of COC of accepting the resolution plan of Kalpraj.
Santanu ji, what do you think about the held portion of this particular case?
Which portion, sir?
This is what was held in this order in Kalpraj.
So, sir, in this order, the Supreme Court held that KIL's delay in appeal can be condoned because they had rightfully, in good faith, pursued a remedy before a wrong forum. They had filed a suit before a wrong court, which was the High Court, whereas they should have gone to this thing. So the this thing was made out that their delay in filing an application before the NCLAT was held to be within limitation. So from the limitation point was this. The second point, of course, comes to the wisdom of the COC.
That Shantanu sir, I guess we are dealing in the chapter.
That we are dealing in the other
I'll just add on to this particular thing. So Supreme Court considered Section 14, and they suggested that since Section 14, which can be invoked in an appropriate case for exclusion of time during which the aggrieved person may have prosecuted with due diligence a remedy before a wrong forum.
Yes.
So here the only contention raised by Kyle was that the provision of Section 14, or at least the principles laid down therein, would be available
should
to
be applicable. Yes.
Right. The only thing that I would like to add is that there should be a bona fide approach to that court which does not have jurisdiction. So this is also kind of this Section 14 has also been used in another case where the SURFACI proceedings were initiated.
Yes.
And I'm only still having one question in my mind. But SURFACI proceedings are not a wrong court.
Yes.
The jurisdiction lies with SURFACI, the DRT court.
Yes.
But still the Supreme Court has given an order that in case the SURFACI proceedings are initiated within the limitation period, and that actually would, the limitation period stands kind of extended for the period when the SURFACI proceedings are pending in a court. This is actually the Section 14 of the Limitation Act. I would actually, when I would conclude this limitation, I would also say what are the different sections where the limitation period can be extended. And this is one of the section, and we've already seen Section 18. We've already seen Section 14 also. So these two sections we've already seen, but there are many sections where the limitation period can be extended. For the time being, we can move on to the other order, which is Sheshnath Singh versus Badyapati Sharafuli Cooperative Bank Limited, and this judgment is also dated March 21, latest judgment, and we have the basic facts of this case will come from Advocate Aditya Gauri. Yes, Aditya.
Aditya? Okay. Aditya? So, okay, let me, I think Aditya is not getting a signal or something.
Am I audible? Am I audible?
Yeah, you're audible. So you have to, can you read out the...
All right, So this was another case. This is also a case that was dealt on limitation by the Supreme Court. Now this in Seshnath case, I'll just briefly take you through the facts. So the company was declared NPA on 31/3/2013. The financial creditor in effect issued notice and initiated proceedings under the SURFACI laws and issued notice under the Section 13(2) of the SURFACI Act in January 2014. The financial creditor thereby took possession of this particular property under, as per Section 13(4) on in 2014 December. The corporate debtor thereby filed a writ petition in the Calcutta High Court challenging the said notices issued by the financial creditor under 13(2) and 13(4) in 2014 December itself. Now, the authorized officer of the financial creditor during the pendency of the writ petition had already taken the possession of the secured assets of the corporate debtor. High Court in 2017, Please note that the writ was filed in 2014 December, and the High Court passed an interim order restraining the financial creditor for taking steps against the corporate debtor as per the provisions of SARFAESI in July 2017. Now, financial creditor being aggrieved by the Kolkata High Court, it went on for a parallel proceedings of NCLT and initiated CIRP while order dated 10/7/2018. NCLT admitted the application.
Yeah.
Now, in the appeal before the NCLAT, sir, I'll just go back on the facts, please. Yeah, so in the appeal before the NCLAT, it was contended that the application was filed on 27th of August 2018, after almost 5 years and 5 months from the date of accrual of the cause of action when the NPA was declared. And therefore, it was barred by limitation. Now, while dismissing the appeal, the NCLAT held that the respondent had bona fide with the period of limitation, initiated proceedings against the CD under the SARFAESI. Now, the issues that came up before the Supreme Court were...
Next page.
Next page, please. That whether delay beyond 3 years in filing an application under Section 7 can be condoned in the absence of any application for condonation of delay as per Section 5 of the Limitation Act 1963. And whether Section 14 of the Limitation Act 1963 applies to the application under Section 7 of the Code. So all the anomalies in the end took turn when, again, that whether Section 5 would be applicable, 14 and 18 and 17, these are applications, the applicability of these sections were taken in effect. Santanu, sir, do you want to...
Yeah, so the SC observed here that the Section 5 of the Limitation Act 1963 does not speak of any application. It enables the court to admit an application or appeal if it is satisfied that the applicant has sufficient cause for not making the application within the prescribed time. Although the general practice of the court is to weigh the sufficiency of the cause for the inability of the appellant to approach within the time prescribed by limitation, there is no bar on exercise by the court of its discretion to condone the delay, and in absence of a formal application. Further, it was observed that Section 238A of the Code makes the provision of the Limitation Act as far as may be applicable to the proceedings under the Code. All provisions of the Limitations Act are applicable to the proceedings of NCLT to the extent feasible. So these words are very important. Section 14 excludes the time spent in proceeding in a wrong forum, which is unable to entertain the proceeding for want of jurisdiction. Therefore, the entire period consumed during SARFAESI proceeding should be excluded. So here, the court basically said that, since the High Court had restrained, on the ground that the cooperative bank may not be able to invoke SARFAESI, on that ground they had passed that stay order. I think they held that it was being pursued before a wrong forum, genuinely, by the corporate debtor, and then that thing could be excluded. It further
I think
said,
I think this is the only issue that we have, whether SARFAESI is a wrong forum or SARFAESI is a right forum for proceeding against the defaulting the borrower. No, if the SARFAESI is a right forum, then the Section 14
will not apply.
When we read Section 14 of Limitation Act, it very clearly says that the case was pending before a wrong forum. And SARFAESI, to my understanding, is not a wrong forum. Probably when we look at the facts of the case, so it is also mentioned that there was a stay by High Court. There was a stay by High Court. High Court passed an interim order on July 24, 2017. And because I think since there was a stay by the High Court, that could have been the reason that it is considered to be a wrong forum. So actually, this is still we would assume that yes, in case the SARFAESI proceedings are initiated, then that period would be excluded from the limitation period, and the applications under Section 7 and 9 or 10 can still be filed if the SARFAESI actions have taken, SARFAESI proceedings have been started.
Yeah, and
I'll just add on to this, sir, that why SIRFACI in this particular case, the High Court stayed the proceedings because the financial creditor was a cooperative bank at
yes,
that point of
yes,
time. So
and
they said that the cooperative bank does not have the jurisdiction to invoke SIRFACI proceedings,
right,
and hence that
right.
all the time that was consumed during the High Court writ petitions, that will be excluded. And similarly, in various other judgments, when it comes to Section 14, again, as Shantanu sir and you had just suggested in the previous judgment of Seshnath, it was suggested that if it is an initiation has been done bona fide with bona fide intentions, then that period shall be excluded as per Section 14 of the limitation.
So,
So
but then I think we have now concluded, since the SIRFACI was not applicable to the cooperative bank at that time. However,
At that time,
yeah,
since 2016, I think there was an amendment in SIRFACI law.
yes.
Now
yeah,
the SIRFACI Act is also applicable to cooperative banks.
cooperative banks, yes,
So this was a pre-amendment case. So it was actually a wrong court. It was not a right court. So our apprehension is still that we are not supposed to guide our clients that if the SIRFACI action is taken, still you would be considered as qualifying for the limitation period. No,
yes,
the
yes,
SIRFACI action, if it is taken rightfully, that may not be excluded from the limitation period. So we can conclude that.
yeah.
Right.
So now we actually move on to Lakshmi Patsurana versus Union of India. Again, this is a very important case, and we all will collectively take up. Aditya, you can start with.
So Lakshmi Pat's case was just delivered by the Supreme Court in the month of March, and it basically cleared out all the anomalies that was going on in the limitations and the vis-a-vis IBC scenarios. So in the facts of the case are that in 2007 and 8, the financial creditor, being the bank, extended credit facilities to two loan agreements to Mahavir Construction, a proprietary firm. Please note, a proprietary firm. The guarantee to the Mahavir Construction proprietary firm was given by one Surana Metals Limited, which was in effect an incorporated company. Now, the stated loan accounts were declared NPA in the year of 2010. The bank then issued a recall notice to the principal borrower, that is Mahavir Construction, which was a proprietary firm, and the corporate debtor demanding the repayment of the outstanding amount. So the bank also initiated a notice to the guarantors. The bank then proceeded to file an application under Section 7 of the IBC on 13th Feb 2019 against the corporate guarantor, which was an incorporated company, before the NCLT Kolkata. Now, NCLT Kolkata was, while misinterpreting the whole grounds, when that it was not maintainable, the Section 7 petition was not maintainable because the principal borrower was not a corporate person, since it was a proprietary firm. And the second reason that was given by the NCLT was that it was barred by limitation, as the date of default was 31/2010, whereas the application had been filed on 13/2/2019, that is beyond the period of 3 years. Now, just to add on to the limitation part, there was also a fact whereby in 2018, Mahavir Constructions, the principal borrower, had also given an acknowledgement and signed a document of acknowledgement suggesting that I still owe you this amount, and hence that was taken on record before the NCLT, but that was not taken into consideration by the NCLT, suggesting that Section 18 of the Limitation Act, which talks about the recurring acknowledgement of debt, does not fall into place with the IBC. The Honorable NCLAT dismissed the appeal and affirmed the judgment given by the adjudicating authority. Now, two issues that was coming up in this particular case before the Supreme Court was that, first of all, whether Section 7 of the IBC can be initiated by the financial creditor instead of going to the principal borrower directly and to the corporate guarantor directly. And the second was whether an application under Section 7 of the IBC filed after 3 years from the date of declaration of loan amount as NPA, being the date of default, is not barred by limitation. And in other words, whether the acknowledgement or recurring acknowledgement would be considered in quantifying the limitation of a particular matter.
So here it was observed by the court that the Section 7 is an enabling provision which permits FCs to initiate CIRP against a corporate debtor. There is no reason to limit the width of this Section 7 and the IBC, despite the law permitting initiation of CIRP against the corporate debtor. if and when default is committed by the principal borrower only. Okay. So basically the Supreme Court concluded here, one, that the even if the principal borrower is not a incorporated person, however, the guarantor is a incorporated person. So the moment the principal borrower has defaulted and the guarantee is invoked, the guarantor, which is an incorporated person, becomes being a corporate debtor. A Section 7 application can definitely be moved against such a corporate debtor. So this was one of the very important finding, that it is not necessary that the principal borrower, if he is not a corporate person, but the guarantor is a corporate person, uh, there is no relation. The debt is owed by both coextensively. So, uh, next page, please. Yeah.
No, I think this is what is
So,
left now.
So it was observed that AA as well as NCLAT have averted to the acknowledgement by the principal borrower as well as the corporate guarantee. Okay, here, as Aditya had also said, that the principal borrower had given acknowledgement to the financial creditor in 2018 that this debt is owed to them. So the Supreme Court held, if this principal borrower has given a continuous acknowledgement, it is not necessary that the guarantor also gives an acknowledgement. The moment they are bound by the deed of guarantee. So if the principal borrower has given the acknowledgement in 2018, it automatically goes on to the corporate guarantor. Therefore, the limitation period has to be taken from 8 December 2018, and hence the application under Section 7 of the IBC filed on 13 February 2019 is very much within the limitation. So here it clears a very important point, that if there is an acknowledgement of debt, that will set in a new period of limitation. The next judgments will further clarify this.
So I think these are two major issues. One is that this section 128 of the Contract Act 1872, which talks about the liability of the grantor and the principal borrower is co-extensive.
Yes.
That will that will trigger, and the financial creditor is free to start proceedings either against the principal borrower, yes, or against the grantor, or against both. So this is the first thing which is clear. Second thing is that even if the debt is acknowledged by the principal borrower and not by the grantor, that would be considered as acknowledgement of debt, and accordingly the limitation period would be extended. So moving on to the final order, which is reconstruction, asset reconstruction, basically ARCEL, Asset Reconstruction Company India Limited versus Vishal Jazwal. While Aditya would talk about the facts of the case, I would just take because this is simple, I'll just take 1 minute gap. Please continue, Aditya.
So Vishal Jazwal judgment was the latest one when it comes to the limitation vis-a-vis the IBC judgments. So in this particular judgment, the last question that arose, and where there was a little doubt whether Section 18 would be applicable or not, and whether acknowledgement of debt would be considered as a recurring condemnation ground for condemnation of delay. So this was held. So in this particular matter, the account of the corporate debtor was declared NPA in 2013 by the original lenders. Thereby, the NPA was assigned to the appellant, who was the financial creditor in 2015. Thereafter, in 2018, the financial creditor filed an application under Section 7 of the Code, which was admitted by the AAA on the basis of annexed copies of the balance sheet of the CD, wherein such debt was signed and acknowledged. Now, in 2018, it is to be noted that the balance sheets, the entries on the balance sheets on the creditor's side was acknowledged by the debtor here. So, the NCLAT, while relying on the V. Padmakumar judgment, which was quite old in its day, and it was technically, taken off by various other judgments of the Supreme Court, held that the set aside the admission of the CIRP of CD, and hence the appeal was taken up to the Supreme Court whether the acknowledgement on the entries in the balance sheet would be termed as acknowledgement, and Section 18 would apply to the said matter. So, Shantanu sir,
yeah, you can go to the next slide, please.
Anil sir was handling it.
Oh, I'll just will not be able to move the slide. Can you move the slide?
I won't be able to.
Okay. So anyway,
I'll just start on the issues. What were the issues that were dealt? So one was being, of course, that whether Section 18 of the Limitation Act is applicable to the code. And the second and the more importantly was whether the entry made in the balance sheet of the corporate debtor would amount to an acknowledgement of liability under Section 18 of the Limitation Act. Now, sir, I'm just going through what was held in the Vishal Jazwal judgment.
Yes.
Just bring on. So the Supreme Court, as recently just decided in the Lakshmi Patsurana judgments and the Seshnath judgments, they were relying on those particular judgments and observed that the rationale for introducing Section 238 of the IBC was to make the Limitation Act applicable to the IBC, quote unquote, again, as far as may be. And it was stated as maybe. Yeah, so that is the basic thing that they have been repeating while they are delivering their judgments on the limitation aspect, that limitation is going to be applicable as far as maybe, and all the provisions should be read to achieve the object of the code and not to degrade the object of the code. So it was stated that there is no reason why Section 18 of the Limitation Act would be excluded from being applicable to the IBC, provided that the acknowledgement of debt is made before the expiry of limitation. So while recognizing that the filing of balance sheet is mandatory under the law, the Supreme Court considered that there is no compulsion to make any particular admission of debts in the balance sheet, as the notes or the auditor's report may enter necessary caveats in relation to any acknowledgement. It was pointed out that notes annexed to the financial statements in this particular case were expressly recognized by Section 134, subclause 7 of the Companies Act 2013, and these notes can hence qualify any entry in relation to a liability in the balance sheet. So in each case, the balance sheet has to be harmoniously read with the such notes and clarifications to determine if the entry regarding a creditor in the balance sheet is made unequivocally or with disclaimers or caveats. So this would then aid in establishing whether the entry in the balance sheet would, amount to acknowledgement or not. And if it amounts to acknowledgement, and if it is read harmoniously, it will amount to acknowledgement, and Section 18 would apply, and it won't be time barred anymore.
So I think with this,
so sir, I think there are some questions coming in.
We'll take up. Yeah. So first, I will do one thing, Shantanu ji, that I will kind of sum up the entire limitation part. Yeah. And after I sum up the limitation part, then we will take questions on the limitation part. And then we will move on to the Committee of Creditors and the commercial wisdom and resolution plans. So this most important is, let us understand the limitation law. The limitation law primarily deals with the two parts. One part, any timeline provided in any act for filing appeal or for filing an application, or any kind of timeline, whatever is provided in any statute for compliances. This is one part of the limitation law. Second part of the limitation law is that the right of a person to exercise legal rights, the period within which the legal right of a person can be exercised. So these are the two parts of the limitation law. And we have dealt with both the parts. And in this part, when we say that the uh, limitation of various timelines provided in the law for filing appeals and applications. So it was in this, it is very important that we should also know this Supreme Court suo motu order on 27th of March 21 decided to extend the period of limitation of filing cases in various legal fora with effect from 14th March 21 until further orders. So originally, when this uh, COVID-19 virus took its all peak, so it was directed by order dated 23rd of March 20 by the Supreme Court, the period of limitation in filing petitions, applications, suits, appeals, all other proceedings, irrespective of the period of limitation prescribed under the general or special law, shall stand extended with effect from 15th March till 15th March 2020 till further orders. So when the Supreme Court saw in March 8th March 21, it was noticed that the country is returning to normalcy. And since all the courts and tribunals have started functioning either physically or by virtual mode, extension of limitation was regulated and brought to an end. Finally, in computing the period of limitation for any suit, appeal, uh, application or proceedings under any general law or special law, whether condonable or not, the period from 15th March 2020 to 14th March 2021 was excluded by the Supreme Court, and that was full 365 days were excluded for the purpose of calculating any limitation for filing any petitions, applications, suits, appeals, and other proceedings. Now, on CC, like this was the order of 8th March 2021. So the first order was 23rd of March 20, when it was said that with effect from 15th March 20 till further order. Then further order came on 8th March 21, when this entire 365 days was excluded. However, on 27th of March 2021, the original order of 23rd March 2020 was restored because the second phase of Corona-19 again was seen. So when the second phase was seen and it was again extended till further order, now whenever the Supreme Court would find that it has again back to the normalcy, then the total period of exclusion, which originally started on 15th of March 2020, is still continuing, number one. So when they have to stop, that the Supreme Court will decide after looking into the various facts. Now, if I would like to talk about the Limitation Act. As I said, the limitation law, then we talk about the Section 5, which talks about the condonation of limitation period by any court based on the reasonable cause, that the applicant was prevented by reasonable cause and he could not comply with the timelines. So then that condonation is under Section 5 of the Limitation Act. That's the power of the court. Then we have various sections which talks about the calculation, like the principles of computing the period of limitation, or you can say the extensions of limitation period. Now, first we will talk about Section 12. See, the Section 12 talks about the exclusion of time in legal proceedings, which includes the day of the judgment. So first of all, the day of the judgment is always excluded, the first day. The second thing is the time for obtaining copies of the order is also excluded, copy of the order, decree, or sentence. That time is also excluded, and the time for obtaining the award shall also be excluded. So in case there are 45 days which is provided in law for filing any appeal, there are 3 days which are supposed to be excluded. One is one is the day of the judgment, and the second is the time for obtaining copies of the order with the reasonable efforts, and finally the time for obtaining the awards, also decrees, sentences, etc. So this is for the first part of the limitation law. Next is Section 13. Section 13 is when somebody says that I had no money to spend, and I was declared as a pauper, so that period can also be excluded. Section 14 we have already dealt with, that the time where the proceedings have been going on in a court without jurisdiction, that we have already dealt with. Then we come to section 15, which talks about the special causes for exclusion of the limitation period, that is caused by a kind of stay, injunction, issuance of an order, or if there is a consent or sanction like this section 15 order, we can always say that the Supreme Court order is section 15 order, where the sanction by government, time during which proceedings to set aside a sale has been prosecuted. This is the special causes of exclusion of times. Then we also can talk about section 17, which talks about the limitation period in the event of a fraud or mistake, and state that the limitation period starts from the date of discovery of such fraud or mistake. So in the case of applications or complaints regarding fraud or mistake, nobody can say that the fraud was conducted, fraud was done in 2012, so the time limit has gone. So in case it is an application for fraud or mistakes, that of course can actually be extended from it, because it starts from the date of discovery. So section 18 we have already discussed, where there is a written acknowledgement. Whenever there is a written acknowledgement of debt of any property, right, or liability from any party, that actually should be it's dealt under section 18, which is called basis of the doctrine of admission, and it is already held in the Vishal Jazwal judgment by Honorable Supreme Court, that the balance sheet acknowledgement would be considered. In case the name of the person is included in the balance sheet, then it is considered as the acknowledgement of debt. So somebody asked me a question that the balance sheet normally doesn't have the names. So then the court said that we have the powers to ask for the item-wise detail of the items. So that is the extension based on the acknowledgement of debt. Now section 19 deals with that the period of limitation starts extended from the time of payment. So whenever the last payment was made, that would be considered as the start of the limitation period. So when we all talk about these kind of sections, then we see what exactly is the limitation law so far that we have seen. So in BK Educational, we have seen that it is to section 238A is retrospective and limitation law is applicable. That was the first judgment. Then in Babulal Vardaraji Gurjar, we've seen that the period of start of the IBC enactment or from the date of default. So it was held that it will be from the date of default. The period of limitation would start from the date of default. Secondly, the period of 12 years would not be applicable to IBC because the proceedings are not considered to be recovery, even if the property is mortgaged. Then the acknowledgement of debt as far as section 18 is concerned is applicable and is valid. So then we saw this Kalpraj Dharmashi versus Kotak. So in that it is it was only on the time allowed for filing of the appeal, because in between that person had actually filed an High Court writ petition. So that particular period was excluded, and section 14 was also considered to be applicable in the IBC. Now the section 14 as regards surface, we've already seen that surface, in case it is in a wrong court and when the law was not applicable, then only it was excluded. And in Lakshmi Patsurana, we've seen that the grantor can also be proceeded against, and the liability is coextensive, and acknowledgement of debt from the time to time by the principal borrower is enough, even if the grantor has not acknowledged. And finally, we have seen the Vishal Jazwal, that the balance sheet acknowledgement is considered to be an acknowledgement of debt, even if it was also argued that the balance sheet is mandatory filing. It is compulsory to prepare a balance sheet. How can this be considered as an acknowledgement? Because the intent of acknowledgement must be there. Balance sheet is not an intent of acknowledgement. But all these arguments were brushed aside by the Supreme Court, and the Supreme Court said that the auditor has all the powers to provide in the notes that these liabilities are not payable. Either it is still there in the liability side, but these are not payable. So this with this conclusion, we can actually see we can now see what are the questions available. So in case Aditya, you can see what are the questions available.
So there is this one question by Mr. Rajesh from DBA Bank, I guess. He asked that if in balance sheet it is mentioned that settlement is in discussion with the lenders without mentioning name of any lender, can it be considered as debt of acknowledgement by CD?
No, in case the balance sheet, because this is only a note in the balance sheet that the settlement is being considered. So when this is said, that means that the name of the financial creditor is already there in the balance sheet, which is signed by the corporate debtor. So just sheer mentioning of the name along with some amount, it will be considered as acknowledgement of debt. The mentioning in the balance sheet that this is some process of settlement is going on, that does not impact limitation period.
Right. So there is this question from Duty Ghai, who asked that when a debt in default is before 2016 and the limitation is expired, will it be covered off by coming under IB code 2016? If yes, the period within which we can file applications under IBC.
So I think again we actually have to see all the sections of limitation law where it will fall. You have to find out the period, entire period, and within that period you have to find whether there was any acknowledgement by way of any letter or by way of any OTS or by way of any letter which is coming to the bank. Second, you have to find whether there is the debt was carried in the balance sheet. The balance sheet debt is also considered to the acknowledgement. Third, that you have to see whether when was the last payment made. So if the last payment was made, that also can be considered as an extension of debt. Or you have to see whether any other action was taken by the lenders. So I think 2016 and the application can be filed within 3 years. However, all these things that I'm saying, that you have to see whether there is anything which is applicable to your case where this limitation period can be extended. Next, Aditya, please.
So there are a lot of questions which are whether the time spent in SARFACI would be excluded to consider limitation after while they want to file SARF.
So we have already said that if the SARFACI Act is applicable on the lender, then it is a correct court and it is a correct proceedings. So that would not be excluded under Section 14 of the Limitation Act. SARFACI action, if already started, that actually would be considered as time barred in case the lender is entitled to start SARFACI action under the SARFACI Act, because then it will not be considered as a wrong court. It will be only considered as proceedings started. But for the IBC, the date of default would be the starting point, and then we actually have to find out the acknowledgement of debt. If even despite that you have started the SARFACI action, but if the company continues to file its balance sheet, continues to hold it as a liability as far as your liability is concerned, then the acknowledgement of debt would be considered as the extension of limitation period. So you would be entitled to file an application under IBC. I think that is like
just
what was the question?
Yeah. So one more question which says that whether one-time settlement offer letter amounts to acknowledgement if the period of 3 years have already elapsed.
Yes, one-time settlement letter also considered to be an acknowledgement for payment of debt, and that letter would definitely acknowledge that the money is payable. I think the most important, still I would say that the most of these companies would be preparing their balance sheets, and the balance sheets would be signed and audited. You can actually see whether the amount is there in the balance sheet or not, and that is the most appropriate resolution for limitation period, rather than see, first we must look into the balance sheet of the company. If the balance sheet of the company is not available, or it is not even filed to ROC, then we can look into the other things like the letter for settlement and all. I still faintly remember that there is a case also where the settlement letter was considered to be an acknowledgement of the debt.
So
not of Supreme Court, but maybe of NCLAT.
NCLAT, sir. So just one last question I'll just put across, sir, which asks that once someone wants to initiate proceedings against the guarantor, so what would be the date of default, whether that would be the date of invocation of guarantee, or whether that would be date of default of the principal borrower?
So as far as the guarantor is concerned, the cause of action starts. First, there should be a default by the principal borrower, and then there should be a kind of invocation of the corporate guarantee or personal guarantee. After the invocation, then there is a default because that guarantor has not been able to make payment, and from that date of default, it will be considered the limitation period have started.
Yes. Not from the default of the corporate debtor.
Not
it has to be from the invocation
yes.
of the guarantee, giving him that time to pay, and he has not paid.
Yes.
From that day it should start.
Yeah, absolutely.
So I guess that's pretty much it when it comes to limitation now.
Okay, participants, like we've already gone through a lot of time, and now we move on to the next important topic, which is the cases on resolution plans. Lalit Kumar Jain, of course, we will only be handling a small part of it, and India Resurgent ARC, very latest judgment, Ghanshyam Mishra, Maharashtra Seamless, and then the very important judgment is the Committee of Creditors of SR Steel, and then Municipal Corporation of Greater Mumbai. And then we start with the Lalit Kumar Jain. It is only the leftover part of this order. Already we have discussed one part, but Aditya, I think we can, this is again the latest judgment, which is 21st of May 21. So we can start with the fact, and we only will talk about the fact which relates to the resolution plan and not about the other part which we already discussed regarding personal guarantors.
So, so this particular judgment, as I had just narrated the facts previously, so this was again against the notification dated 15th of November 2019, and the notification was challenged. And while challenging the notification, it was held that the personal guarantor would be, it was contended that the personal guarantor would be absolved once the resolution plan is passed and the resolution plan is approved by the NCLT. And it was said that since as per section 128 of the Contract Act, there is the liability of the guarantors and the principal borrower is that of a coextensive nature, and hence that once the corporate debtor is absolved of all the liabilities after the resolution plan is passed, the personal guarantor would also be absolved. So the Supreme Court, while dealing with the constitutionality of the said notification, also dealt with this particular thing and clarified. And the issue that was clarified was, so can you just put on the next slide? So the issue was whether on approval of resolution plan, the liability of the personal guarantors to the corporate debtor gets extinguished as the liability is coextensive in nature.
So here it was held that the sanction of a resolution plan and finality imparted to it by section 31 does not per se operate as a discharge to the guarantor's liability. The resolution plan, which states that the claims of the guarantor on account of subrogation shall be extinguished, cannot be applied to the guarantees furnished while the erstwhile directors of the corporate debtor, quoting the COC SR versus Satish Kumar Gupta listing. An involuntary act of the principal debtor leading to loss of security would not absolve the guarantor of its liability. So basically, the resolution plan is an operation of law. It's not a mutually agreed, OTS or settlement between a corporate debtor and its lenders. The resolution applicant is a different entity. So, if by resolution operation of law, the debt of the company has been settled at certain amount, that does not absolve the personal guarantor of his dues, which he must pay, and it can be independently pursued by the lenders, and any recovery made out of the personal guarantor will also not have a right of subrogation vis-a-vis the new owners of the company. So this was always held by NCLAT and many these things. This Supreme Court has also dealt with this. This is in much clarity. So now this is absolutely clear.
So we move
Sir?
on to the other resolution, other things which are related to the powers of the Committee of Creditors and the feasibility and viability of the resolution plans and the other matters of the resolution plan. So I think this order, this judgment, like India Resurgent ARC Private Limited versus Amit Metalink Limited, again a judgment of 13th May 21, the latest one. So this is little disturbing, but yes, we need to discuss it.
Right. So in this judgment as well, the Supreme Court, while relying on various judgment as delivered by it in the previous years in SR or Arcelor or various other judgments, talked about the commercial wisdom of the COC and how they have proper rights and they cannot, go out of the four corners. So the case here was that the appellant was a secured financial creditor of VSP Udyog Private Limited, who was a corporate debtor. The resolution plan was submitted by the RA, which was Amit Metallics Limited, and was considered for voting by the COC. The COC, by giving approval, the COC with the 95.35% of approval, passed the resolution plan, and the same was kept in front of the AA for approvals. The appellant expressed reservations on the share being proposed, particularly with reference to the value of the security interest held by it, and chose to remain a dissenting financial creditor. Now, here the point of consideration before the Supreme Court when it came was that whether the feasibility and viability of a resolution plan, the distribution proposed with reference to the order of priority amongst creditors, as per the statutory distribution mechanism, including priority and value of security interest of secured creditors, are matters which fall within the exclusive domain of COC for consideration, or whether they fall within the domain of the AA.
So this was actually a very important. So I would like to take up this
Yes, sir.
held portion. When we see section 30, subsection 2, it says that the dissenting financial creditor should get equivalent to that amount which they would be entitled to in case the company goes into liquidation. Now, in case a dissenting creditor has a security interest which has a value, and he is likely to get that value in liquidation process because he will invoke section 52 and he will take away his property and he will sell that property. See, assuming that a company has, assuming that a bank had given 50 crores of loan, and against that loan he had actually an exclusive charge on a property which is having a value of say 60 crores or 40 crores. Now he says that the resolution plan is not proposing that kind of payment to me. So he would choose to be a dissenting creditor, saying that he is entitled to, as per section 30 subsection 2, and also as per regulation 38 of CIRP regulations, amount equivalent to the value that he would get in case the company goes into liquidation. In company goes into liquidation, he will invoke section 52, he would get his property maybe 40 crores or 60 crores. So this is what he was fighting. So when he was fighting this, however, the court has held that the scope of the judicial review remains limited within the four corners of section 30 subsection 2 of the code for the adjudicating authority, and section 30 subsection 2 read with section 61 subsection 3 of the appellate authority, quoting JP Kensington and K. Shashidhar. It was also held by the court, the financial proposal in the resolution plan forms the core of the business decision of the COC. Once it is found that all mandatory requirements have been fully complied with and taken care of, the process of judicial review cannot be stretched to carry out quantitative analysis qua a particular creditor or any stakeholder who may carry his own dissatisfaction. It was held that what amount to be paid to different classes or subclasses of creditor in accordance with the provisions of the code and the related regulation is essentially the commercial wisdom of the committee of creditors, and a dissenting secured creditors like appellant cannot suggest a higher amount to be paid to it with reference to the value of the security interest. As we understand, whenever we look at the mandatory contents of the resolution plan dealt by section 30, subsection 2 and regulation 38, it is one of the mandatory conditions. It is one of the mandatory contents, and it is mentioned that if the mandatory contents are not fulfilled or complied with, then the resolution plan will be considered as legally not valid, legally not compliant. So in case a creditor who has a security interest, an exclusive security interest, and if he says that this is the liquidation value which is due to me, that liquidation value should have been paid to him or should have been provided for, seeing that he may dissent from the resolution plan. However, this order could not envisage that, and this order was giving powers to the COC, and it was held in this case that the adjudicating authority cannot even talk about the amount which is separately payable to each creditor. Anyway, we move on to the next judgment, which is Ghanshyam Mishra and Sons Private Limited through the authorized signatory versus Edelweiss Asset Reconstruction Company. Yes, this is April 21. We have actually taken up the latest judgments. So the April 21 judgment, and these are the facts.
Yeah. So in this particular case, the resolution of Ghanshyam Mishra and Sons and Private Limited was approved by the COC in the CIRP of Odisha Manganese and Minerals Limited. The RP, there was a claim filed by Sundargarh Mines and Transport Workers Union on behalf of the workmen of the corporate debtor, and the RP had rejected that claim filed by the claimants. Now, while there were applications to go against the resolution plan and to seek processing of the resolution plans, because there were various applications by the statutory bodies, the local authorities and the central government, that their claims were not determined by the RP as yet, and there was an appeal by application by the Sundargarh Mines Workmen Association. So NCLT, without considering them by an elaborate order in 2018, approved the resolution plan. The NCLAT, while dealing with the appeals, held that the RP ignored their rightful wages, statutory dues and other benefits. And the NCLAT, while determining the resolution plans, had directed that the people who at the parties that who have not been made part of the resolution plan may go before other forums and try to recover their money. So the issues which were dealt before the Supreme Court in this particular manner, in this particular matter, were that whether any creditor, including the central government, state government, or any local authority, is bound by the resolution plan once it is approved by an adjudicating authority, whether the amendment to section 31 by section 7 of Act 26 of 2019 is clarificatory, declaratory, or substantive in nature, as in whether it is retrospective or not, and that whether after approval of resolution plan by the AA, a creditor, including the central government, state government, or any other authority, is entitled to initiate any proceedings for recovery before any other forum for their money.
So Shantanu, this is important. You can take up this held part.
Yeah. So it was held that once the resolution plan is duly approved by the adjudicating authority under section 1 of subsection 31, the claims as provided by the resolution plan shall stand frozen. So basically, the essence of the judgment is once a resolution plan has been approved by the authority, the adjudicating authority, it is binding in rem. It is binding against every stakeholder. And if any debt or claim is not crystallized as on that day or not claimed, then that stands extinguished in perpetuity. So let's say the income tax authority or any other authority cannot just initiate uh, you know separate proceedings after a new person has taken over the company. He should get the company in clean slate. So all dues held in para 97, all dues including statutory dues owed to the central government, state government, any local authority, if not part of the resolutions plan, shall stand extinguished, and no proceeding in respect of such dues or for the period prior to the date of which the adjudicating authority grants its approval under section 31 would be continued. So no past dues which are not part of the resolution plan can be proceeded against in any other forum. So
So
this
it is
gives
very
a
important,
finality.
Shantanuji. Yeah. So finally, it is very important, Shantanuji. Like, let us conclude in a very simple manner. One, that whatever be the liability of the corporate debtor, before the approval of the resolution plan, that actually will be restricted to or reduced to whatever is the amount, restricted to that amount which is provided in the resolution plan. Now, there is no question whether these parties were part of the resolution process or not. These parties have filed the claims or not. So all liabilities before the approval of resolution plan would stand extinguished or will be reduced to the amount which is provided in the resolution plan. So as we are dealing with many cases where there are disputes regarding land or regarding joint venture agreements, so if the claim is not filed by the landowners, so far they have been thinking that we would not be part of the resolution plan, resolution process. So the resolution plan, if approved, would not be applicable to us. So that is clarified now, that is held by the Supreme Court, that they may not be part of the resolution process, they may not have filed the claim, but their liability stands extinguished in case the resolution plan is approved. So this is a very important development in the insolvency law, and it specifically includes multiple times the dues towards the central government, state government, local authorities. So there is no question about any legal or any tax dues or any other dues. So this is very important judgment, and it is not very old. It is in April only, in March. The Maharashtra Seamless Limited versus Padmanabhan Venkateshwar. This is also a January 21 order, and Aditya will take it through the facts.
Yeah, so the application was filed by the resolution professional for the approval of the resolution plan for United Seamless Tubular Private Limited, which is the corporate debtor. The approval was in respect with the resolution plan. The Maharashtra Seamless Limited was the resolution applicant in this particular case. The tribunal passed a detailed order to redetermine the liquidation value of the corporate debtor and then place the revised resolution plan before the COC for voting, which was not duly followed by the RP. The RP informed the tribunal about the order of the adjudicating authority to redetermine the liquidation value, and it was complied, and which was now the redetermined value, liquidation value, was now at 597.54 crores as compared to the previous amount of 439. So Maharashtra Seamless Limited had already deposited an amount of 477 crores, and this matter went to NCLAT that whether the adjudicating authority was right in determining or redirecting the RA to reconsider and bring in more money through their resolution plans. So the NCLAT, while going through the order as well, affirmed that the RA should pay another additional amount of rupees 120.54 crores, which would then be par with the average liquidation value of the corporate debtor, making the value of the resolution plan from 477 to 597.54 crores, which comes in consonance with the liquidation value. So now the question before the Supreme Court which came forward was that whether the scheme of the code contemplates that the sum forming part of the resolution plan should match the liquidation value or not. And in the particular case, there was also a fact based that because due to the ongoing litigation and the NCLAT directing the RA to reconsider the amount, the RA wanted to withdraw their resolution plan as per Section 12A. So this question also came that whether Section 12A of the code is applicable route through which successful resolution applicant can retreat.
So it was held that adjudicating authority cannot interfere on the merits of the commercial decision taken by the committee of creditors, quoting K. Shashidhar. COC should make sure that the corporate debtor needs to keep as a going concern, because the rationale being that during the resolution, the corporate debtor remains a going concern, whereby the financial creditors will have an opportunity to lend further money, the operational creditors will have a continued business, and the workmen and employees will have job opportunities. That it needs to maximize the value of its assets, and the interests of all stakeholders, including operational creditors, has been taken care during the insolvency resolution process. No provision of the code or regulation has been brought to our notice. This is what the Supreme Court said, under which the bid of any resolution applicant has to match the liquidation value arrived at in the manner provided in clause 35 of the Insolvency and Bankruptcy Board of India Insolvency Resolution Process, Corporate Person 2016. So basically what the Supreme Court has very clearly said, that it is not necessary at all that a resolution plan has to match or has to pay the average liquidation value. If the COC feels in its commercial wisdom that this particular plan, though it is less than so-called resolution, the liquidation value, is the best plan, and it will keep the, meet the other objectives, then COC is very much within its right to pass such a resolution plan. And this I can even say from a personal case that I have handled, where we have approved, my COC has approved a plan which is less than the liquidation value, which is of course pending for approval with NCLT. But it is very much clear that liquidation value is just to aid the COC in determining what could be the best this thing. But it is not mandatory that if a plan is below liquidation value, it cannot be accepted. It should not be accepted. This is a misconception lot of bankers also have today, that we cannot accept anything which is less than liquidation value. But see, this is IBC is a resolution law and not a recovery law. So it has to be seen in context. If the company is going to restart again, so this is a very welcome judgment, and this is a very landmark judgment, I feel. If Anilji would like to add anything.
No, I think the one thing that we have observed, that the adjudicating authority in fact tried to find some faults in the valuation report.
Yes.
Tried to realign the valuation report, and another additional valuation, the valuation was increased as adjudicated by the adjudicating authority, and it was also ordered that the resolution applicant should pay something like 127 crore in addition to what the resolution plan was. So the Supreme Court has finally held that yes, the adjudicating authority does not have that power to ask the resolution applicant to pay additional. Secondly, there is no provision that the resolution plan should offer amount equivalent to or closer to the liquidation value. Third, that this Section 12A is only applicable to the applicants. Section 12A is only applicable to applicants of the application and not to the resolution applicants. So in this particular case, the resolution applicant tried to invoke Section 12A, but the court said that no, 12A is only for the applicant who originally filed the CIRP application. So that was also one of the points which was held. I think now we are reaching to this Committee of Creditors versus SR Steel India Limited versus Tish Kumar Gupta, and this is like 15th of November 2019 order, and it is on the approval of the resolution plan. The brief facts are being narrated by Aditya. And so, also issues also you would be attending, Aditya.
Yeah. So this is by far the the biggest judgment by the Supreme Court when it comes to resolution plans and the process to be followed. So the original resolution plan in this particular case was submitted by ArcelorMittal and later approved by the COC, provided that the operational creditors with an exposure of an amount of INR 1 crores would forego the entire amount. So the NCLT approved ArcelorMittal's original resolution plan and directed the COC to consider sharing 15% of the amount that was recovered from the profits made during the CIRP with the operational creditors of SR Steel. Now, the NCLAT in its final judgment approved the resolution plan of ArcelorMittal but directed redistribution of proceeds among the creditors of SR Steel. The NCLAT, while going through the plan, held that the resolution plan should not differentiate between the financial and the operational creditors in the manner of the payment of the dues. However, leaving aside Section 53 and various other sections of the code. The NCLAT further directed that the redistribution of proceeds payable under the resolution plan such that all financial creditors were paid an amount of 60.7% of their admitted claims, and the operational creditors were also paid somewhere around the same amount of their admitted claims. Now, being aggrieved by this decision, the financial creditors, amongst others, challenged the decision of the NCLAT, whereby NCLAT wanted that financial and the operational creditors should be standing on the same viewpoint when it comes to distribution of money. So the issues that were dealt by the Supreme Court in this particular matter. So the issues that were dealt by this particular matter was whether undecided claim will continue to operate against the corporate debtor on approval of resolution plan by the adjudicating authority or not. So undecided claims being that whether the resolution, again, the resolution plan has been passed or, any new claims are going to be considered or not. So, Shantanu sir, would you want to take the vote?
So, see, this was one of the very landmark judgments wherein obviously the Supreme Court struck down, and it's a very well-known judgment, I'm sure everyone knows, struck down the redistribution of the proceeds by NCLAT, saying that NCLAT really has no jurisdiction to get into the commercial wisdom of the COC. It upheld that intelligent classification among different classes of creditors can be made.
The business decisions of the COC were again highlighted that they cannot be infringed.
And it also said that if you leave the resolution applicant, successful resolution applicant, facing very different claims and different this thing, then this would amount to a hydra head popping up, which would throw into uncertainty amounts payable by the prospective resolution applicant who successfully take over the business of the corporate debtor. Therefore, all claims must be submitted and decided by the resolution professional so that a prospective resolution applicant knows exactly what he has to do, what he has to be paid in order that he may take over the business of the corporate debtor and begin on a clean slate. See, that is the most important thing. Now, if I take over a company under resolution, and then I have to still deal with past debts, past this thing, then who is going to come for a resolution? So this is a very, very clear judgment. So the successful, held in para 67, the successful resolution applicant starts running the business of the corporate debtor on a fresh slate, and claims will not may exist part of those apart from those decided on merits by the resolution program. Basically, if any claim has not come in, if any claim is not crystallized, then it is not a part of this thing. Then it is extinguished. So this is a very clear judgment. Enclad judgment was revolutionary in its own way at that point of time. And obviously everybody thought that Supreme Court would hold otherwise, and Supreme Court rightly held otherwise, because if ultimately the adjudicating authority starts deciding the commercial wisdom, then what is left for COC to do?
So that's very right, Shantanu. Now, let us discuss what is considered to be undecided claims and what the court is referring to as a hydra head popping up. I think this hydra head is kind of a water animal which is known to be like you chop one head, so the new head will come up. You chop another head, the another head will come up. So the heads will never finish, and you will never be sure whether the water animal is died or not. So when we see this kind of undecided claims, so let us try to find out what could be the undecided claims who are not part of the resolution process. So various statutory liabilities which are not assessed. Now, for example, service tax, GST cases which are not assessed. And whatever we are talking about up to the period of approval of resolution plan, including the CIRP period. So if there is any notice which comes later on, any fresh demand is created for the period prior to the approval of resolution plan by adjudicating authority, all that would be considered as undecided claims and would be extinguished, because the resolution applicant who is taking over the company will take it over on a clean slate. He would have a complete clarity that whatever he has provided in the resolution plan, he has no additional liability over that. He would also not be worried about all the pending assessments of all direct or indirect taxation. He would also not be worried about all crimes or all kind of criminal activities or non-compliances of various laws, various penalties which could have been levied on the company. All that would be crystallized to zero, because the new management will start from clean slate. All these claims, all these notices, all these penalty notices, all these inquiries, all these inspections are called as hydra head popping up. So that is in case that be so, then nobody would buy uncertainty. Everyone would like to buy certainty in under IBC. That is one reason that I always say that even if you are investing in a MSME, even if you are becoming partner of an MSME, do it through PIRP, because this NCLT stamp, applicability of section 53, the process of claims and the process of hydra head not popping up, or the concept of clean slate will protect every person who is participating into a business today. So with this, I believe we have concluded this judgment also. And since it was a very important part of the insolvency.
I think you should also say that now it is further strengthened with section 32A. That the past criminal these things will not, they can't attach the, corporate debtors assets.
We had decided that 32A will be dealt separately altogether.
Oh, next chapter session.
Altogether. That's
next
big
okay. Fair enough.
So this is an order which is like November 2019, Municipal Corporation of Greater Mumbai versus Abhilash Lal, and this probably Aditya will take you through.
Yeah. So the corporate debtor, which was Seven Hills Healthcare Private Limited, entered into a lease agreement with the Municipal Corporation of Greater Mumbai for a land owned by the Municipal Corporation in Andheri East to create a 1,500 beds hospital. The MCGM in return asked for 20% beds for underprivileged and allowed a period of 6 months for the construction. However, due to financial restraints or whatever, these conditions were not fulfilled, as the construction did finish within the stipulated time, that is till April 24th, 2013. The resolution plan was submitted by one Dr. Shetty's New Medical Center, and the MCGM was alleging to be a financial creditor and alleged that the tenant was employed under the financial lease, and the unpaid lease consisted of the financial debt. So MCGM, while the process for resolution applicants and process was taken forward, the MCGM insisted that the resolution plan must be made in accordance with the Mumbai Municipalities Act and must be approved by the MCGM Development Committee. The application was dismissed by NCLT. MCGM thereby approached the NCLAT, stating the same reasons that their master plans and everything should be, and the by rules and bylaws should be complied with by the resolution plan, and it should properly provide for the rules and regulations as provided by the Mumbai Municipalities Act. So MCGM approached the Supreme Court, and so there was the consideration point was that whether the NCLT approved resolution plan get a stance over all other legislations. So here the topic of 238 and other legislation and resolution plans were taken up. Over to you, sir.
So Shantanu ji, would you take up, or?
Yeah, I can take up.
You please take up.
See, the principle that the statute, it was held that principle that a statute requires a thing to be done in a particular manner should be done in that particular manner or not at all, as articulated in Nazir Ahmed versus Emperor, is an old case. Now, if alienation or creation of an interest in respect of MCGM's property is contemplated in a statute through a particular manner, that end can be achieved only through that prescribed mode or not at all. Section 238 cannot be read as overriding MCGM's right, indeed its public duty to control and regulate how its properties are dealt with. The authorities under the code could not have precluded the control that MCGM undoubtedly has under law to deal with its properties and the land in question, which undeniably are public properties. The resolution plan, therefore, would be a serious impediment to MCGM's independent plans to ensure that public health amenities are developed in a manner that it chooses and for which the fresh approval under MMC Act may be forthcoming for a separate scheme formulated by the corporation. Held that there is no approval of the plan in accordance with law, the resolution plan cannot forcefully bind the third parties at MCGM. Now here there was one small difference, because there is one more judgment. I don't know whether we are covering that. That is RK Bhuta versus MIDC. Okay. Now there are two things. In this particular case, the lease agreement was to come into force after the construction was over. So the lease agreement was not created. It was more of a MOU. Okay. Whereas in RK Bhuta, the lease was already there. So the Supreme Court had adjudicated there, held there, that since the lease was there, no doubt that the property belongs to the MIDC, but the lease, it is not the property which is being sold or which is being taken over by the the resolution applicant. It is only the leasehold rights that is being transferred to the resolution applicant. So in RK Bhuta, they very much ruled that the resolution plan would be binding on MIDC. Whereas in this case, but there is a very small difference in this. In this case, the lease was to be entered after the construction was over in 6 months' time, whereas in RK Bhuta, the lease was already there.
No, I think, Shantanu, there is a concept here which we would actually like to explain in detail, and that concept is what is within the power of adjudicating authority or the appellate authority or under the IBC. So, what kind of decisions they can take, what kind of jurisdictions they have. So we can talk about that this particular scenario that we have concluded in other cases also, that there is a concept of public law and private law. So the public law is when there is a one party. There one party is the government or central government or state government or any local authority, and there is a separate structure for dealing with those kind of issues. So all those issues cannot be brought to the jurisdiction of adjudicating authority under IBC. So in this case also, since this the Municipal Corporation of Greater Mumbai, they actually had a MMC Act, and there was a structure which was formulated by the Municipal Corporation of Greater Mumbai for handling such kind of disputes and issues. So therefore, this becomes a public law. So wherever there is a public law, the jurisdiction would not be concentrated to adjudicating authority. However, in a private law, so the private law is where both the parties are private and none of the parties are having any authority, maybe central government, state government, or local authority. So all those public law would not be concentrated to adjudicating authority, and this kind of approval has to be obtained from that respective department or the authority. However, all other things should actually come to the jurisdiction of NCLT. This is what we actually can conclude in our next, or we can deliberate on this in our part 2. Although
Yeah,
this,
we should.
although
These two judgments,
although
RK
this,
Bhuta.
we can actually discuss about it. Although there are about the commercial wisdom of the COC, there are some orders that we would like to discuss, but because of the paucity of time, and we would like to take it up in this in part 2 of the same subject.
Yes.
However, we can take up some of the questions in case there are. So in part 2, we will start with the commercial wisdom of the committee of creditors, and we will also take up the further issues which has been decided by Supreme Court of India. So Aditya, in case you can see whether there are some questions as of now, so we can even discuss those.
So sir, there is one question by Dikshat Mehra, which asks that what if plan mentions that the personal guarantee has to be discharged on approval of plan? Will that mean it will be binding on stakeholders, or FC can still proceed against the PG?
No, see, the question is very important because see, like I still couldn't understand a scenario where the personal properties or the personal guarantee of the promoters can be part of the resolution plan. The reason number one, because see, there may be see, like let us understand 2 or 3 scenarios. One scenario is that there are 3 financial creditors. All the 3 financial creditors have personal guarantees and have the personal properties also. So a resolution plan is filed where the personal properties and personal guarantees are part of the resolution plan, and if approved, the promoters would be absolved from their personal guarantees and collateral securities. Now, scenario 1 is that all the three financial creditors who have this kind of security interest, they all vote for the resolution plan, then there will not be any person who would be objecting to it. And that can still be made part of the resolution plan, although IBC never says that you can make the personal assets also as part of the resolution plan. However, that can still survive. However, in case one of them becomes a dissenting creditor and he says that I have never participated into the resolution plan, so the inclusion of personal guarantee and the personal properties of the promoters is outside the purview of IBC, so that resolution plan can be challenged. For most appropriate implementation of the IBC, I would say that the personal guarantee and the collateral securities of the promoters should be kept away, should be settled separately, and should not be part of the resolution plan. However, in case there is only single, in case all the creditors who have that kind of interest on the personal guarantee, if all of them decides to vote for it, then it may survive. But if what is the way that the RP will know whether everyone will vote or not? So when RP is presenting a resolution plan, he should highlight that this resolution plan also includes absolving the personal guarantors from the personal guarantee or from their personal collateral securities. So that's what is a concept which is very important.
Right. So the next question is that what happens if the resolution plan is approved by the COC, but the same is pending adjudication before the NCLT? So what happens to the claims being submitted after approval of the resolution plan by the COC, and as the resolution applicant has not considered those claims? And how do we treat such claims?
Once the resolution plan is approved by the committee of creditors, thereafter any claim which is filed that is likely to be rejected, and this Supreme Court judgment would be applicable as in the as said in the Asser Steel versus T. Gupta, that any undecided claims would be extinguished even if they are not part of the resolution process, and that includes all authorities, central government, state government, or local. So any claim filed after the approval of the resolution plan would probably be considered as extinguished.
So there is another question by Mr. Ravi Shankar. He says that in case of MSME, where the same promoters continue and there is no change in management, do the criminal cases and unclaimed creditors claims extinguish because IBC provides that criminal cases will be cancelled?
So what is the question?
So he says that in case of MSMEs, where the same promoters continue and there is no change in the management, the criminal cases and the unclaimed creditors claims would extinguish or not?
No, see, the unclaimed creditors case, the claims would be extinguished because it is that particular judgment of Supreme Court is applicable. Hydra head popping up is applicable even if the same promoters are continuing. So that is regarding the civil liabilities, financial liabilities. However, as far as the criminal liabilities are concerned, those would continue, as it is also continuing into non-MSME cases. The criminal liabilities would continue against the promoters.
So I'll just take one last question, sir. So there is this question which asks that what would be the status of personal guarantors under the PIRP scheme?
So the personal guarantors under the PIRP scheme will also have the same concept. One, that if the base resolution plan is approved, then I believe the creditors would also resolve the personal guarantee of the promoters. Now, in case in the base resolution plan, if the liability of 100 crore is reduced to 50 crores, then the liability of the personal guarantors also stand reduced to 50 crores if the same promoters are continuing. However, in case the different set of management comes and take over the MSME corporate debtor, then the financial creditors, secured financial creditors, they would have all the powers to proceed against the promoters, and they can start personal insolvency of those promoters. However, in case the resolution plan is approved from the same promoters, from the same directors, and the liability is accepted to be reduced, or the banks are accepting the haircut, that haircut would be applicable to the personal guarantee also.
I guess, should we take any other questions? Because there are a lot of questions, but we are lacking.
I think we can note down these questions and we can even take up in the next part 2 of this. So what I believe is that the participants are active and they are raising questions, and these are all relevant questions. We would not ignore these questions, and we will take up these questions in the part 2, which is on the next Sunday, starting at 4 p.m. Anything that you would like to say, Shantanu ji, so that after that I
No,
will
sir, I
conclude?
think it's very active. I can actually, I was reading through a lot of questions. Of course, not all essentially relating to the topic, but general practical questions, I think, coming from our IT colleagues. And we should try to,
No, we will
uh,
definitely,
address them
we will
in some
address that.
manner,
Yeah.
given that the collective experience that we have as AAA of having handled all sorts of situations. So very active. I think at one point of time there were 166 plus
No, I have seen even
people.
210. I
I
mean,
think
anyway,
So
that's
230
210.
much
plus.
more
So
than that.
which is really
So
good, sir, that on
very,
a Sunday
very,
afternoon everybody has taken out their time, and we should thank them for their interest, and this encourages us to do more such webinars to share knowledge and also learn. So I think, sir, we should thank everyone, and then from my side I thank everyone, and we can close the meeting now.
great, sir. Thank you very much. The panelists, collectively, all of us have worked very hard on this, and I thank you, the panelists. I thank you, the legal team. I thank Advocate Aditya Gauri for taking time out and participating in this webinar. Thanks, participants, and we will continue our effort of spreading awareness, sharing our knowledge and experience, and finally, this is our way of learning. Thank you very much.
Thank you.
Thank you. Thank you, everyone.